Hello, everyone. I'm Michelle Herzog, the History Social Science Coordinator for Los Angeles County Office of Education, and thrilled once again to welcome you to our monthly webinar series with the National Constitution Center. I know many of you are from LA County, but we've got some folks from around the country here too to hear our very special speaker today. We're very excited about that. So let me quickly turn the time over to my good friend at the National Constitution Center, Carrie Sautner, who's going to introduce our special guest. Thanks, Carrie.
Thank you. It's exciting to have everybody here tonight. I'm going to do a really quick walkthrough of the National Constitution Center's information, because we know that we all want to bottle up Professor Foner and bring him into our classrooms. And guess what? The National Constitution Center kind of did that. We have many recordings and tools and writings of Professor Foner that we're able to share with you. So really quickly, I'm just going to go through some of those tools and what we're going to do tonight. So first, let's begin with a simple agenda, introductions from the team, and also turning it over to Professor Foner to be able to dive deep into this idea around the Reconstruction Amendments and their impact on America. And then we'll have a wrap up at the end, share some more resources with you, and a Q&A will be also at the end of Professor Foner's conversation. So if you don't know the Constitution Center, really quickly, we are a nonpartisan civic education organization. We have a museum in Philadelphia, but we also have one of the most robust constitutional educational tools online. We're the second most visited website of a museum in the United States this month in a row for the last 3 months. So we beat MoMA, really happy about that. So great ways to engage in the Constitution in a nonpartisan way and to dive into this understanding of our history and have discussions about it as well. So we were chartered by Congress in 1988, and we opened our organization's front doors and online doors in 2000. We broke ground in 2000 and opened in 2003. Our learning framework is really based off of what we're going to experience tonight. This idea that we teach our constitutional history through historic foundations of storytelling, the stories of we the people. How do we understand those stories? How do we pull them together and see their impact in our lives? We at the Constitution Center, we frame everything in constitutional thinking skills, and that's really about posing constitutional questions that matter for all of us, but it starts with what may our government do? What can our government do? Not always starting with the should questions, and we'll dive into that next in a minute. But key to everything we do and kind of that tip of the point is really to have civil discourse and dialogue with each other and with people that think differently around the Constitution, giving ourselves time to reflect on our own thoughts as well as ideas from others, and really not to change your opinion, but to broaden it and understand different perspectives. So our framework really wraps around everything we do. And when we think about the difference between a political and a constitutional question, it does go back to that idea that a political question is typically, what should we do? If you hear yourself say that and say, what is a political question? It usually starts with, we should do that, or we shouldn't do this. But what we do at the Constitution Center, let's say, you know what? Let's all start with the constitutional question. What may the government do? What may it not do? Starting there and understanding that, those political conversations are so unbelievably important, but we like to begin everybody with that constitutional framework through the storytelling and those questions, so then we can build on that together and see which areas we want to dive into deeper. As we kind of think through this even more, tonight's conversation will be unbelievably relevant to this understanding and these constitutional questions. So Professor Foner is going to walk us through all this amazing information. And he is, I'm just gonna pull this out of here. He is the top scholar in the United States on Reconstruction, a huge friend of the National Constitution Center, and I'm pretty sure 90% of our staff's favorite scholar that we get to talk to, which is why half of us are all on this call together, learning and listening with you. So the big question that we want to start off with around for Professor Foner is the 13th, the 14th, and the 15th Amendments. They ended slavery in America and try to rebuild our nation on a stronger constitutional foundation. Do you think that these amendments changed the Constitution so much that they were a rebirth or a second founding? So with that kind of big constitutional question, really bringing in the three big heavy hitters of the Reconstruction time period, I'm going to turn it over to you, Professor Foner. Make sure everybody, as Professor goes through these conversations, this storytelling time, please feel free to ask questions in the Q&A. I will collect them. And at the end of about 20, 25 minutes, we'll jump over to you guys and pull questions from you as well. So without further ado, to you.
Okay. All right. Hi, Carrie. Thank you very much for introducing me, and thanks to all the teachers out there. I'm very happy to be meeting with you today, even though remotely. I have many times in my career, I have spoken to pre-collegiate teachers at conferences, at high schools, at other venues. I always enjoy doing that. I usually begin by saying that I know that you have a much more difficult job than we do at the college level, partly because every student in my classes at Columbia University chose to be there. So that gives you an advantage. However, nowadays, I think it's even more so, given how many teachers are having to deal with Zoom and remote learning and all these difficulties. So, you know, it's much appreciated what you are trying to do under very difficult circumstances. So I will talk for a little while, as Kerry said, about the 13th, 14th, and 15th Amendments, how they changed the Constitution, how we should view them. And then I will welcome questions, comments, so please feel free, send them over to Kerry, even as I'm talking. And then I will try to answer some of them after 20 minutes or something like that. Now, the 13th, 14th, and 15th Amendments to the U.S. Constitution, as you all know, were passed and ratified between 1865 and 1870. And they are the most tangible legacies today, I think, of the Reconstruction era after the Civil War. My book that was published a year or so ago is called The Second Founding. Therefore, my answer to Kerry's question is yes, these amendments do constitute a second founding. What I mean by that is that they really created a new constitution in fundamental ways. They were not just you know, small additions or changes in an existing structure. They really did change the structure in ways that I hope to talk about this evening. They reflected and they reinforced a new era of what we might call rights consciousness in the United States among Americans of all races and all backgrounds. They wrote a new definition of citizenship into the Constitution. They forged a new relationship between individual Americans and the national government. If you don't like the term second founding, I will suggest you use the term that the Republican leader Carl Schurz used to describe them, the constitutional revolution. That's what these were in the Reconstruction era. Now, I am not going to give you a long historiographical discussion. You all know that interpretations of Reconstruction have gone through many changes, starting with the old Dunning School, which viewed this as a period of corruption and misgovernment, and saw the constitutional amendments as just an example of radical Republican vindictiveness toward the defeated South. The point I want to actually make about this is that that idea, long ago discredited and abandoned by historians, survives today still in popular consciousness to some degree, and even in places you wouldn't expect it. In 2004, I think it was, Chief Justice Rehnquist of the Supreme Court wrote a little book about the disputed election of 1876, which led to the ending of Reconstruction, as you all know. And in that book, he started out, first of all, it was a book that had no worth as a history at all. It was worthless. I don't know why the Chief Justice did this, but he wanted to establish his reputation as a historian. He didn't use any works that had been published in the past 50 years, so it was rather out of date. And one of the reasons was he basically argued that these amendments were just a vindictive punishment to the defeated South. The idea that expanding the rights of Black people is a punishment to white people is a very dangerous idea, actually, and that the Chief Justice of the United States held to that notion, well, at least suggested that he wasn't going to be very sympathetic to using these amendments to further expand the rights of African American people. But my real point about this is that even though we may not realize it, Reconstruction and the issues of these amendments are part of our lives today. Who is a citizen of the United States? That's being fought over on our southern border as we speak. Who should have the right to vote? Today, there are legislatures all over the country trying to regulate and limit and suppress the right to vote for various citizens in their states. That's a Reconstruction question, though. That issue arises immediately out of Reconstruction. What about terrorism? The Reconstruction era, sadly, was a period of domestic, what we call today, domestic terrorism. The Ku Klux Klan, violent groups like that. The events of January 16th, a couple of months ago, were not unprecedented in our country. Reconstruction saw armed mobs of white supremacists overturning democratically elected local governments. They didn't try to do it in Washington, but certainly you had the Wilmington riot in North Carolina. This is a little after Reconstruction, which a coup d'etat, which ousted a biracial government in that city. The Colfax massacre, similarly in Louisiana during Reconstruction. In other words, it established unfortunately, a mode of dealing with a political difference. Now, at any rate, to understand how these three amendments changed the Constitution, we have to just very quickly look at what the status was on the eve of the Civil War. First of all, most African Americans, of course, were slaves, nearly 4 million of them. Slavery was extremely powerful, not only economically, but in helping to shape the definition of American nationality. On the eve of the Civil War, no Black person could be a citizen of the United States, at least according to the Supreme Court in the Dred Scott decision of 1857. Before the war, though, free African Americans themselves, abolitionists, these are small groups but very vocal, put forward a different constitutional vision of the United States. They put forward a vision of a citizenship which went beyond the boundary of race, which applied equally to all Americans, and that legal and constitutional principles should not make distinctions on the basis of race. That is the vision that was written into the Constitution in the 13th, 14th, and 15th Amendments. Before the war, free Black people who held their political conventions called them conventions of colored citizens. They were claiming the right to citizenship, which the society largely denied them. Now, the first of the three Civil War amendments, of course, was the 13th, ratified in 1865, which irrevocably abolished slavery throughout the United States. It introduced the word slavery into the Constitution for the first time in the act of abolishing it. The founders had protected slavery in significant ways, the Fugitive Slave Clause, the 3/5 Clause, but they used circumlocutions. They spoke of persons held to labor. They spoke of other persons. The word slavery was not in the Constitution until the 13th Amendment put it in there. Why was the 13th Amendment necessary anyway? Hadn't Lincoln freed all the slaves in the Emancipation Proclamation, January 1st, 1863? In fact, as I'm sure you know, the Emancipation Proclamation left in bondage about 750,000 of the 4 million slaves. It only applied to those states in rebellion against the United States. It was a war measure seeking to weaken the Confederacy by disrupting the foundation of its economic order, slavery. The four border slave states, Maryland, Delaware, Kentucky, and Missouri, were not included because they were not at war with the United States. The way they were still in the Union, their constitutional protection of slavery still applied to them. So that's about 750,000 slaves not covered by the Emancipation Proclamation. And therefore, even after the proclamation, Lincoln pursued his longtime aim of state-by-state abolition. Slavery is created by state law. The federal government, the general opinion was, could not intervene in a state to abolish slavery, but states could abolish slavery by themselves. And Lincoln made it very clear that no state was coming back into the Union unless it abolished slavery. But the border states also would have to do that by themselves until the 13th Amendment abolished slavery throughout the United States. Now, one of the points I want to make here is that these three amendments were all fought over. They were compromises. They were ambiguous. They were powerful documents, but they also had loopholes, mistakes. One of those loopholes, which has gotten a lot of attention very recently, is in the 13th Amendment. I'm going to pull out my little Constitution here and read to you what it says. Neither slavery nor involuntary servitude, except as a punishment for crime, shall exist within the United States. The criminal exemption. Involuntary servitude is barred except as a punishment for crime. Why was that language in there? Well, recently there was a Hollywood documentary, 13th, very good in many ways, about this, although it sort of had this conspiratorial idea that the people who wrote the 13th Amendment anticipated mass incarceration in the year 2021, and were trying to create the basis for that. That is not really quite true. There were hardly any prisons at all when the 13th Amendment was ratified. But the fact is that it did create a loophole which was later used, particularly in the southern states in the late 19th century, for a massive system of convict labor, where Black people were convicted of petty crimes and put in jail and then leased out to plantations and railroads and mines to labor with no compensation whatsoever in very, very dire conditions. And the courts have consistently ruled that that is allowed under the 13th Amendment. In fact, they have also ruled that prisoners do not have to be paid. There is still prison labor today, not being leased out, but inside of prisons themselves. Minimum wage laws don't apply to them, all because of the loophole, so to speak, in the 13th Amendment. Nonetheless, the 13th Amendment, in abolishing this central institution of American life, slavery, was certainly a radical departure from the pre-war world. Most of the Republicans who enacted it saw it, to use a modern term, as a step toward regime change, replacing a pro-slavery pre-war regime with an anti-slavery one. But the 13th Amendment raised more questions than it answered. Number one, what was going to be the status of these 4 million people who had been slaves and are now free? What did it mean to be a free American? What was actually being abolished? What does it mean to abolish slavery? Was racism also being abolished? Racism was central to American slavery. Was that being abolished? And how would one do that? And so further legislation and further constitutional change became necessary to flesh out the meaning of the 13th Amendment. In early 1866, Congress and President Andrew Johnson began to go their separate ways on Reconstruction. Congress enacted the Civil Rights Bill, the Civil Rights Act of 1866, which for the first time made anyone born in the United States a citizen of the United States with no racial bar whatsoever, and stated that all these citizens had to enjoy equality of civil rights. It didn't apply to the right to vote, but the right to own property, the right to go to court, the right to sign contracts, the rights, in other words, enabling you to compete in the economic marketplace, these were to be enjoyed equally by Black, white, and all other Americans. That law passed over President Johnson's veto, it marked a significant change. It was really the first federal law that tried to establish a principle of equal treatment before the law for all Americans. But a law, of course, can be repealed. So very quickly, Congress put these principles into the 14th Amendment, the most important change in the Constitution since the Bill of Rights. It's a long amendment. It is complicated. Some parts of it are virtually incomprehensible. It was a series of compromises between the radical and moderate factions of the Republican Party. One way of looking at the 14th Amendment is that it constitutionalizes the Republican Party's conception or understanding of what the Civil War had accomplished. Some of it deals with things which are sort of arcane and not relevant today. It bars compensation to slave owners for the loss of their property in slaves. It guarantees the federal debt that it cannot, in some odd language, so the sanctity of the federal debt cannot be questioned. Questioning is one thing, but what they really mean is it can't be repudiated. The federal government has to pay its bills or its debts when it borrows money. But more significant, lately, two other sections of the 14th Amendment have come to the fore, about which there is really no jurisprudence at all. First is Section 2, which was a compromise between radicals who wanted to give the right to vote immediately to African-American men, particularly in the South, and moderates who wanted to sort of encourage that, but were afraid it wasn't politically popular enough to be ratified. So what Section 2 says is basically, if a state denies to any group of male citizens the right to vote, it is going to lose part of its representation in Congress proportionately. So, for example, Alabama at that time was about half Black, half white. It was up to Alabama whether to give Black men the right to vote. But if they didn't, they would lose half their congressmen. Now, this provision has never been enforced. It is supposed to be automatic. The language says they shall lose it's not may or might, they shall have their representation reduced. I am the founder, let me get my little document out here. I'm the founder of, here it is. Can people see this? Well, you can't really read it, but this is the American Association for the Enforcement of Section 2 of the 14th Amendment. Now, this is an elite group. It only has two members, me and Professor Gabriel Chin, a law professor in the University of California. We're not looking for a mass movement. We just want to get this on the political agenda. My point is that today, as we speak, many states are passing voter suppression laws, denying people the right to vote. Some of them are disfranchising enough people that they ought to lose one or two of their congressmen. The ones I have in mind are Georgia and Texas, both of which have a lot of members of Congress. And if Section 2 were enforced, would lose a couple and should. That's what the amendment says. Section 3, very little jurisprudence, a little bit in Reconstruction, came to the fore just in the last 2 months. Section 3 of the 14th Amendment bars leading Confederates from ever holding office again until given amnesty by Congress. Any person who took an oath to support the Constitution and then gave aid and comfort to the enemies of the Constitution is barred from public office by Section 3. This was raised against President Trump. President Trump took or ex-president now, obviously, took an oath to support the Constitution encouraged a mob which stormed the U.S. Capitol on January 6th. And many people said that Congress should just declare him ineligible for future office as a result of Section 3 of the 14th Amendment. Again, it's supposed to be automatic. It's not a trial. It's not an impeachment proceeding. It can be enforced simply by a majority of Congress. I wrote an op-ed in the Washington Post calling for the enforcement of Section 3, not only against President Trump, but against any public official. And there were a number who took part in the rioting of January 6th. So the 14th Amendment sort of keeps popping up. But the key section, of course, is Section 1, which begins by reiterating this notion of birthright citizenship. Anybody born in the United States is a citizen, regardless of race, and goes on to prohibit the states from abridging the privileges or immunities of these citizens, although it doesn't say what those are, or denying to any person, not citizen, person, any person, alien, immigrant, citizen, the equal protection of the law. This is the critical part of the 14th Amendment. The word equal is not in the original Constitution, except where it talks about what happens if candidates get an equal number of electoral votes or something like that. The 14th Amendment makes the Constitution what it never was, a vehicle through which aggrieved individuals and groups who believe they are being denied equality can take their claims to federal court. And this part of the 14th Amendment transformed Americans' relationship to the government. It proclaimed that everyone in the United States is to enjoy a modicum of equality guaranteed by the national government. All in all, as a newspaper editor said at the time, the 14th Amendment changed a constitution for white men into a constitution for mankind. Now, all three of these amendments, we get to the 15th in a minute, end with another section saying Congress shall have the authority to enforce this amendment. Congress shall have the power. Congress shall have the power, let me get the exact wording here, 14th Amendment. Congress shall have the power to enforce by appropriate legislation the provisions of this amendment. This marked a radical change in our federal system, the relationship between the federal government and the states. You can understand my point if you look at the Bill of Rights and compare it to these amendments. The Bill of Rights, the First Amendment, begins with the words, Congress shall make no law, abridging the freedom of speech, freedom of religion, or establishing a establishment of religion, et cetera, freedom of the press. It's applied to, it's a bar on what Congress can do. It had no bearing before the Civil War on the states. Try to give a speech against slavery in South Carolina. You couldn't do that. That's against the law. What about the First Amendment? That's irrelevant. That applies to the federal government. This is a state law, no problem. But now, the 14th Amendment and all three of them say the states cannot do these things. The states have to respect the liberties enunciated in the Bill of Rights. And the federal government is overseeing the states to make sure that they treat Americans properly. So from being a danger to liberty, the federal government moves to becoming, as Charles Sumner, the great abolitionist senator, said, the custodian of freedom. Now, the 14th Amendment did not give anyone the right to vote, but soon in the 15th Amendment, Congress does try to guarantee the right to vote of African-American men. What its 15th Amendment says is, well, let's see, what did it say? The right of citizens of the United States to vote shall not be denied on account of race, color, or previous condition of servitude. Now, this is a radical thing also. Before the Civil War, only black men, first of all, women could not vote anywhere at this time, of course, black or white. The feminist movement wanted this amendment to bar discrimination on the basis of sex as well as race, but of course that was not included. Before the war, only about 5 states, all in New England, with minuscule Black populations, allowed Black men to vote. But now, this is being, now all the states have to allow Black men to vote. But here we have another loophole. The amendment says people cannot be denied the right to vote because of race. But what about other ways of denying people the right to vote? States realized after Reconstruction was over that they could use literacy tests, poll taxes, property qualifications, grandfather clauses, which would affect Blacks much more than whites, and yet didn't mention race. If they just passed a law saying, hey, Black people can't vote, the courts would strike it down. But over time, the Supreme Court allowed measure after measure that fundamentally eliminated the Black vote, even though, but not using the term race in the law. In 1903, in Giles v. Harris, where Giles from Alabama sued to overturn Alabama's disenfranchisement laws, the Supreme Court just threw up its hands and said, you know, if the white people of Alabama want to stop Black people from voting, there is nothing we can do about that. In other words, the Constitution is not self-enforcing. And sadly, over the long period after Reconstruction, the Supreme Court played a central role in the whittling away, or really abrogation, of the 14th and 15th Amendments under the Jim Crow system in the South. Now, I've gone longer than I wanted to. I do want to leave time for questions, so I'm going to stop and simply say, one, many of these decisions of the Supreme Court are still good law. They're still out there. They have never been overturned. They have been, the courts have moved around them in many ways, but the Supreme Court has never had the gumption to just say, you know, we have been wrong for 70 or 80 years in how we interpreted key parts of these amendments. Let's start over, because there are still, there's a latent power in these amendments that has never really been utilized by the Supreme Court. So I think knowing what's in the 13th, 14th, and 15th Amendments, and knowing how they have been used and might be used in the future is will be a very valuable thing for all of us as citizens, and particularly for our students who are trying to see how this history relates to the present day. So let me stop there. I'm going to let Carrie come back on and pose questions, and we'll try to answer them, okay?
And I'm going to go through systematically through the chat, but one kind of piece on that, before we get into that, around the Supreme Court kind of gutting the power of these amendments. And the other fault here is also with Congress not using the section to enforce, to have the power. Were there any real big moments where they attempted to give power back to these amendments through their power?
That's the 13th Amendment, basically the court just said, oh, it's irrelevant. Slavery's gone, and that's it. The amendment accomplished what it wanted to do. There were those who said, but there are what we call the badges of slavery, the incidents of slavery, the results of slavery. Shouldn't those also be under attack if you're really abolishing slavery? On rare occasion, particularly in 1968, when it upheld the sort of national open housing law, the Supreme Court said, yes, housing discrimination is a badge of slavery. The federal government under the 13th, not 14th, 13th Amendment has a right to abolish it. But that's that's really the only case in which that has happened. The 14th Amendment, what I think is apart from the second and third clauses, which have just never been enforced. Now, the NAACP, early in the 20th century, did ask Congress to enforce Section 2 and bar a certain number of Southern congressmen, because the whole Black population was disenfranchised, and yet Section 2 is never enforced. But the Southern states had enough power in Congress to prevent the implementation there of this amendment. But what has really weakened the 14th Amendment is what the Supreme Court calls the state action clause, that the 14th Amendment's guarantees only apply to, only prohibit discriminatory action by the states, by governments. In other words, it doesn't apply to an individual or a business who wants to discriminate. And as civil rights laws about public accommodations and everything got passed in the 1960s, the Supreme Court weaseled around and upheld them, but not on the basis of the 14th Amendment, on the basis of the Commerce Clause. Congress has a right to regulate interstate commerce. If a business will not allow a Black person to come in and buy something, that is interfering with interstate commerce, even if it's just in one place. They weren't willing to get rid of this state action idea, which is still alive. It's not that long ago that the Supreme Court overturned a portion of the Violence Against Women Act. Violence against women is bad. They admitted that. But the fact is that Congress only has the power to bar it. Governmental action. If the governor, hey, I'm from New York, maybe it should be used. If the governor uses violence against women, I guess that's bad. That's state action. But private violence, individuals, no. It's not a federal crime. The states have to deal with that. And the 15th Amendment, very bad. Lately, the courts have said, well, these voter suppression laws, by and large, yeah, we know they're really trying to bar Black people, poor people, Hispanic people, but they don't say it. They don't say race. They use these other qualifications like having to have an ID of some kind, etc. And the courts have upheld most of these as not being violations of the 15th Amendment. So to my mind, there is a big problem in the jurisdiction, in the jurisprudence right now of these amendments. I'm not totally optimistic that with its current makeup, the Supreme Court is particularly interested in reinvigorating the 13th, 14th, and 15th Amendments.
Awesome. Okay, so let's dive into these questions. I have about a million more around Section 2 of the 14th, but I think our teachers do as well. So Kevin first asked, and you referenced the 13th Amendment show and 13 and what kind of they got wrong there. Kevin wants to know, did you see Amend yet from Netflix? And yeah. What are your thoughts?
I'm in Amend. I'm one of the talking heads. But unfortunately, I never got to meet Will Smith, who was sort of the guru of Amend. But nonetheless, yeah, Amend is pretty good. It's a 6-hour thing. I mean, it's six hour-long episodes which start out with the 14th Amendment. It's all about the 14th Amendment, not the other amendments. I think it's pretty good if you feel like spending 6 hours watching about amendments. I know people in the National Constitution Center don't mind that. What it shows is how the 14th Amendment, in this contradictory way, has expanded to include all sorts of groups who were not on the minds of Congress in 1866. Most recently, gay marriage, for example. State laws barring gay people from marrying are a violation of equal protection of the law. If the law says straight people can marry, it's got to let other people marry too. That's what equal protection means. Now, obviously, Congress in 1866 was not thinking about gay marriage, but this is a matter of the expansion of the principle. Many of the key decisions of the late 20th century, one man, one vote, 14th Amendment, right to privacy, 14th Amendment. All these measures knocking down state laws that interfered with personal liberty, 14th Amendment. But where it has been very weak is actually vis-a-vis Black people, which was the original intention to protect the rights of the former slaves, as well as everyone else, but particularly them. And the court has, over and over again, the sort of cut back on affirmative action, cut back with invalidated the Voting Rights Act, a few years ago, the act from 1965. They're much more happy to apply the 14th Amendment to other groups than in race relations. And when it does come to race relations, the court lately has been much more sympathetic to the claims of white people that they are being discriminated against, for example, by affirmative action. So rather than African Americans claiming a greater right. So again, it's to my mind, I say this at the National Constitutional Center. I'm not trying to stir up resentment against the 9 men and women on the Supreme Court, but I think their jurisprudence really needs to have a second look in these areas.
Okay, next question. So Tyler wanted to know more about the amendments being ratified, the process of ratification. So here's Tyler's question. How should we think about the requirement of ratification of the Civil War amendments in order for Southern states to rejoin the Union after the Civil War? Does this present a legitimacy problem for the amendments? And we've heard this kind of bubble up over the years. So that's really what Tyler's trying to get at.
Right. No, over the years, this particularly Southern defenders of the Southern way, or whatever they want to call themselves, have said, yeah, that these amendments, it's really the 13th and 14th. The 15th was a different question, but President Andrew Johnson, that they were illegitimate because of the way they were ratified. President Andrew Johnson demanded that the Southern states ratify the 13th Amendment before being fully readmitted into the Union. Now, you know, it's a funny thing. Were they in or out? Lincoln, of course, said, this is like how many angels can dance on the head of a pin. You know, the Constitution simply does not say anything about what happens if a bunch of states secede and levy war against the country. The founders didn't imagine such a thing. Lincoln said, no, you can't secede. Therefore, they're not out of the Union. Therefore, we need 3/4 of the total number of states. Now, there were Northerners who said, no, they're not here. They're gone. They've seceded. They're at war with us. We can't let them vote on whether or not the Constitution has changed. But Johnson required them. Now, when we say required, they could have said no. Their legislators said, forget that. Mississippi didn't ratify, actually, until I think 1975. It takes a long
it's
time.
really late. Really
late. They finally woke up and said, you know, I think slavery actually has been abolished. There's not much we can do about this in 1975. So they could stay out under military rule, but nonetheless, yes, to require a state is unusual. 14th Amendment is even more unusual. President Johnson had set up these all-white governments, which were discriminating all over the place against blacks with so-called black codes, laws, etc. And Congress wrote the 14th Amendment partly to overturn those laws, and they sent it out to the states. They said, fine, you know, but every single Southern state except Tennessee refused to ratify the 14th Amendment. And without them, it couldn't be ratified. So what did Congress do? They said, well, we're getting rid of those governments. They're no good, obviously. So in the next year, they basically set up the process of abolishing the Johnson governments, allowing black men for the first time to vote in the South, and having the Army register voters, and then electing new state legislatures. And those legislatures had to ratify the 14th Amendment. If they wanted to come back into the Union, again, they had a choice. They could say, no, forget it. We don't want to come back. We don't want to have our power in Congress. We're just going to stay here under military rule. So they had a choice, but still they couldn't get back in unless they ratified the 14th Amendment. 15th Amendment is different. By then there were functioning Reconstruction governments throughout the South with black men voting and holding office, and those governments just ratified the amendment like everybody else. There was no requirement that they do so. You know, this has also come before the Supreme Court on occasion. And the Supreme Court said, we're not touching this one with a 10-foot pole, forget it. The Secretary of State, William Seward, both times, declared that the 13th or 14th Amendment had been legally ratified. And that's how you know it's ratified, when the Secretary of State announces that it's been ratified. Supreme Court said, well, he announced it's ratified, so it's ratified. We're not going to bother. We're not going to do anything about this. You know, this is what some law professors call revolutionary constitutionalism. That is, they went beyond, obviously, the ratification process in the Constitution, but that is because they were still operating within the context of a civil war. Mm-hmm. So, you know, yeah, maybe someday the Supreme Court will say, sorry, those amendments are not in the Constitution, actually. I'm sure there's plenty of people who would like to see that, but I think it's unlikely at the moment.
Got it. Awesome. Thank you. Okay. Now, of course, you knew a slaughterhouse case question was coming. So in 1869, this is from Joseph, the Supreme Court ruled in the slaughterhouse case. In their decision, they bifurcated citizenship between state citizenship and national citizenship. Nice use of bifurcated. How exactly did the court come to that conclusion?
1873 actually was slaughterhouse. And that was the first of a long line of cases that seriously limited these amendments. And as the questioner says, yes, it's an interesting case because the plaintiffs were white. They were not African Americans. They were white butchers. The legislature of the biracial Reconstruction legislature of Louisiana had passed on as a health measure, had passed a law to created a monopoly of the slaughterhouses, animals for meat. At the time, they were all over the city. They stank up the place. Their carcasses floated in the Mississippi River. It was a big health problem. And like many other cities and states, they said, well, we're regulating this. We're just going to have all this concentrated in one place. White butchers who were losing their livelihood because they were not part of this monopoly sued that on the grounds that in the liberty guaranteed let's take it back. Among the privileges and immunities of citizens guaranteed by the 14th Amendment is the right to pursue a livelihood, the right of free labor. That's what the war was all about, free labor versus slave labor. And therefore, this law should be called unconstitutional under the 14th Amendment as a violation of the privileges or immunities of American citizens. The court said, no, that's not correct. The 14th Amendment did not alter the federal system fundamentally. You still get most of your rights from the state. In fact, federal rights are almost non-existent. What were they? What are those privileges and immunities? Well, the right to protection against pirates on the high seas. That didn't really bear on the lives of most Black people at that time. They weren't being kidnapped by pirates. What about, or the right to go to Washington to petition the federal government? But most of your basic rights are still under the purview of the states, and they upheld this law. They said this is a perfectly reasonable law for a state to pass to regulate things. And, in a way, they're upholding Reconstruction. It's a law passed by a biracial Reconstruction government. Most of the people on the court are Republicans. They support Reconstruction at this point, but they don't want to completely unbalance the federal system. They don't want, as they said, the federal government to be a perpetual censor on the laws of the southern states. If we turn this down, we're going to be inundated by people claiming that this law is a violation of privileges or immunities, or that law is and then leave it with the states, with the federal government sort of remotely off, just in case things get out of hand. Unfortunately, this opened the door for states to do all sorts of things, violating the rights of citizens, with the Supreme Court rarely intervening. So it's a funny case, and it was only decided 5-4. Most legal scholars consider this was a wrong decision. It should be, there are people who've been claiming it should be overturned. Clarence Thomas has said recently that in a case that he just said it off, it's almost off the top of his head. Oh, by the way, slaughterhouse was wrong, and really we ought to overturn it. Why have a wrong decision still out there? But that's not likely to happen. Some of them, Alito said, no, we can't do that. It's ridiculous to start overturning things from 150 years ago. So yeah, slaughterhouse was the beginning of a long train of decisions that weakened these amendments.
Awesome. I feel like I need to make like a gut it joke, how they gutted the 14th Amendment, but I'll stop. Okay, so Kimberly Huffman wanted to understand, is there any record of the citizenship qualifications debate that they can consider the impact of determining presidential qualification? For a modern context, the debate regarding eligibility of someone like Ted Cruz or John McCain.
Well, these are two different things, of course. The original Constitution says that the president must be, quote, a natural born citizen. whatever that means. That seems to suggest that if you're born in the United States, you're a citizen of the United States, which is what most people assume, but it didn't apply to Black people. It was a racial thing as well. And what about Native Americans? Oh, yeah. If you try to get into that, forget it. It's awfully complicated. But now the 14th Amendment says anybody born in, it says explicitly, anyone born in the United States, with a couple of minor exceptions, well, not so minor, mostly Native Americans on reservations, which was important at that point, is a citizen or naturalized. But those naturalized citizens cannot become president. Now, this, again, has never been litigated to my knowledge. I mean, that's why Henry Kissinger couldn't run for president, right? Ted Cruz, what? He was born in Canada, right? His parents were American citizens, presumably. What about Romney? Wasn't Romney born in Mexico? I think he was, when his parents were, as Mormon missionaries, were down there. So it's a little unclear. If your parents are both American citizens, but you're born outside the United States, are you eligible to be president of the United States? And the question is, the answer is, we don't know. This has never been we've never had someone, where this is adjudicated, where someone had to decide, is this person? But we do know that naturalized citizens, immigrants who became citizens, are not eligible to be president or vice president. McCain, okay, right? Oh, if McCain was born, someone says, on a military base.
Cuba,
well, I guess
right?
Military base is probably considered part of the United States.
Yeah, I think they determine that with military bases. So, because it is like a section and sanction of United States government. So, two people, Aaron and Larry, both have questions around Section 2. So, what is holding it back from being utilized? And then Larry's follow-up question, which he posed as a silly protocol question, but I love it. Does Section 2 need updating due to the gendered and age restricting language? Is denied any of the male inhabitants, such as the state. So does it need updating? And then also there was another question about, could there be a class action lawsuit that calls on Section 2? So you got a bunch of questions around Section 2. Everybody got excited.
Again, this is not, the Supreme Court, whenever that came before them, said, well, this is a political question. It's up to Congress to discern. We're not touching this one either. Enforcing Section 2 the reason Section 2 is there is to try to have a disincentive for states to just start denying people the right to vote all over the place. Now, it is absolutely true, as the questioner said, it does include the word male, which the women's movement at that time was very angry about. It put the word male into the Constitution for the first time. If a state denies any male citizens the right to vote, then they'll lose representation. But if they deny women the right to vote, there is no penalty. And every state at that time did deny women the right to vote, of course. But it made a sharp distinction between the sort of role of men and women as members of the body politic. Discriminating as women does not come with any cost. Discriminating against any group of men is supposed to come with a cost. But that, I think, is considered just moot anymore because of the 19th Amendment, which gave women the right to vote. So, for example, in the qualifications for president, I said the word male doesn't exist in the original Constitution, but the pronoun he does exist. The president, he must be 35 years of age. He. Well, what if Hillary Clinton had been elected? And somebody said, well, wait a minute, she's not a he. She can't be president. And then the court was, well, no, giving the right to vote to women has abrogated those things that made women that put women outside the body politic. So I would say that it doesn't need anything. I think that the 19th Amendment overrides the gender discrimination in the 14th Amendment and the qualifications of president. Now, how would you enforce? The problem is, how do you enforce Section 2? It's easier said than done. Who decides which? Texas has, let's say Texas has about 30 members of Congress. I can't remember how many they have. And all you'd need is to disenfranchise like 3% of your citizens to have Section 2 activated. But who would decide which of those 30 people is no longer eligible to be in Congress? I don't know. Would it be Congress? Would it be the state legislature? Would it apply retroactively or in the next election? I mean, look, the implementation of anything requires a lot of, operation. So I'm not saying it shouldn't be done. It should be done. But because it hasn't been done, there is no, pathway. There's no tradition on how a state would actually be denied part of its representation in Congress. But at least the effort to enforce it might be a deterrent for states, just as they are today, trying to keep a lot of people from voting. I think Section 2 deserves another look, given the large-scale voter suppression that is going on today.
Maybe it's done by district. So if the district is suppressing the vote.
Well, it's normally a state would be suppressing. In other words, a state law, let's say, ending mail-in voting, let's say, and the courts rule, well, this is obviously directed against this and that. Let's say the ending of mail-in voting deprives 5% of your citizens the right to vote. You should lose 5% of your members of Congress. That would not, but that would apply to the whole state, not just a particular district.
Yeah, and I wonder if it's like certain states limit in certain counties, not just mail-in voting. So mail-in voting is allowed, but the county only has one drop-off site.
Well, that's the yeah. But again, I don't know. Maybe
I'll figure that one out.
Well, let's go to Congress and see if we can discuss this with them.
Yeah. So next question from Daniel. When mostly conservative justices call for an originalist reading of the Constitution, do you think that they would accept the Reconstruction Amendments as part of the originalist Constitution, or would they consider it an abbreviation? And I love that question because we get that all the time. So when you're thinking about originalist around the Reconstruction Amendments, you go back to, Thaddeus Stevens and Sumner, right? Like, how do we understand these pieces?
Well, you go back to a whole bunch of them. As I say, these were compromises. There is original intent is a judicial principle. No historian, it is completely incoherent intellectually. It has no intellectual value. The idea that any significant document has one original intent or one original meaning is ridiculous. There are all sorts of things went into these amendments. And whose intent are we talking about? The people who wrote it, the people who voted in Congress, the people who were in the state legislatures ratifying it. For example, the 14th Amendment, there were no Black congressmen in Congress when the 14th Amendment was passed by Congress. But by the time it got to these legislatures later on, there were Black members of the legislatures. So shouldn't we consider what Black people thought the purpose of the 14th Amendment was? But they never appear in the literature because they're not there in Congress when it was being debated. These amendments, were, as I say, there were all sorts of purposes put into them, both idealistic and partisan and all sorts of others. And, yes, you can pull quotes. It just sort of takes you into the congressional record and just sort of, let's find a quote from someone who's saying, who's debating what does this mean or that mean, but what did John Bingham say, etc. But the court has pretty much, in the 14th Amendment, as I said before, many of the key decisions have nothing to do with original intent. What was the original intent about school segregation? There was none. It wasn't discussed at all. The court had to decide what to do. What was the original intent about one man, one vote? There was none. What was the original intent about gay marriage? Well, conservatives on the court asked that question in the Obergefell decision. We're expanding the 14th Amendment way beyond the original purpose. That's probably true, except it's the principle of equality that is being applied. It's not the specific group. It's the principle that is the original purpose that is being applied there. So, I think judges have to think for themselves, and to try to run this country on the basis of what people were thinking in 1787 or in 1866 is a fool's gold.
Okay, next question from Ryan. How were other minority groups such as Asian Americans and Native Americans affected by these amendments at all and at the time in half or last half of the 1800s? And I know you touched upon the Native Americans lightly,
Yeah,
but how was this applied?
well, that's a great question, and it's very complicated. Now, the law prevented Asians from becoming naturalized citizens. No one from Asia, up to 1870, only white people could become naturalized citizens. 1870, Black was also added, so people from Africa could become naturalized citizens, but Asians could not become naturalized citizens until well into the 20th century. 14th Amendment doesn't change that. What it does say, though, is people born here, so the children born in the United States to Asian immigrants are American citizens. And that's what the Supreme Court ruled in the late 19th century, that this applies, if the language is clear, if you're born in the United States, you're a citizen. Now, so both among Chinese Americans, Japanese Americans, this distinction within the community developed between the immigrant generation, which could never be citizens, and then their children who were citizens. And that causes all sorts of complications within these families and communities as time goes on. Native Americans, very hard to describe. The idea was that they were still citizens of their own tribal sovereignties. They were dealt with by treaty rather than federal law, mostly. So basically, they were not under the jurisdiction of the United States, and therefore birthright citizenship didn't apply to them, particularly if they were living on reservations. Now, if a Native American moves to Chicago, they may become a citizen, actually, because they're no longer subject to the jurisdiction of their tribal reservation. In 1924, the federal government passed a law saying that all Native Americans are citizens, which they are today. Of course, with Native Americans, it's awfully complicated because many Native Americans did not want to be American citizens. They wanted to be citizens of their own nation, the Cherokee Nation or the Choctaw Nation or the Comanche Nation. They objected to being absorbed into the notion of citizenship, which is pretty unique. It's hard to think of another group that has taken that position, but to them, freedom meant tribal sovereignty. And the 14th Amendment and then these laws were undermining that. So Native American citizenship is, like everything else we've been discussing today, pretty complicated.
The NCC is going to make a T-shirt that just says "It's complicated."
Right.
Let's talk about it.
True of all of these things.
I think one last question.
Okay.
So what would you say would be the most significant SCOTUS case that undermines the Reconstruction Amendment? Was it the Slaughterhouse case, or is there another?
Now, to me, it's the civil rights cases of 1883, where Congress had passed the last Reconstruction bill, which was the Civil Rights Act of 1875, which prohibited discrimination on the basis of race in transportation, in public accommodations, private businesses, etc. If you're serving the public, you got to serve everybody. Supreme Court, 1883, overturned that, said the 14th Amendment, again, only applies to state action. So an opera house which refused to allow a Black person in, that's not a problem. That's not the state. That is the individual business, and the 14th Amendment has nothing to do with it. It puts this state action doctrine right into the middle of 14th Amendment jurisprudence. Now, the critics, of whom there were many, that was not a popular decision in many parts of the Republican Party, said, well, wait a minute, a state that allows this kind of discrimination among its citizens is taking action. To allow this kind of degrading of some part of the citizenry is itself a form of action, and therefore that should be barred, excuse me, under the 14th Amendment. But the Supreme Court has never accepted that. To me, that was, it took many, many years until the civil rights case of 1964 to, in effect, overturn that. And even then, as I said, they didn't change the 14th Amendment interpretation. They used the Commerce Clause to get around it. So the civil rights cases of 1883, That decision has never been overturned.
So on that, and one final kind of wrap up thought, I've heard you say this before, and I was wondering if you still were kind of in this mindset that the civil rights movement of 1965s, would you consider that a second Reconstruction kind of movement in generation?
Yeah, well, that term was used at the time, the second Reconstruction, because it was the second time that a national effort was made to really try to combat the long legacy of slavery, Jim Crow, etc. And the legal foundation, despite everything I've said, the legal foundation went back to the Reconstruction Amendments. It was the 14th Amendment they were trying to use, the 15th Amendment, which allowed the Voting Rights Law of 1965 to be enacted. Even the 13th Amendment, as I said, in the open housing case. So, yeah, I think a second Reconstruction. Now, today, there are people saying we need a third Reconstruction. We need a Reconstruction that'll deal with the criminal justice system. We need a Reconstruction that'll deal with economic inequality, which is not just a question of blacks and whites. Reverend William Barber, the leader of the kind of grassroots radical movement in North Carolina, has written a book basically saying we need a third Reconstruction. So I'm on his team.
You're going to get another club together.
All right.
All right. Thank you so much. This was a fantastic class. Everybody join us. Thank you so much for joining us. We will follow up with the recording and some other emails around this conversation. But Professor Foner, as always, thank you so much. It's so fascinating to talk about Reconstruction.
Absolutely. Thank you very much, Carrie. Bye-bye to everybody.
Bye, everyone. Thank you, everybody. Have a good night. I got almost all your questions in.
You did a fantastic job, and I have to say thank you that this is literally a dream. When I saw it in the email, I ran to my wife and I'm like, we're gonna get to talk to Professor Foner. It was very exciting. So thank you so much for making this possible.
Awesome. I'm sorry I couldn't. Well, let me stop the recording so I don't have to sound like a goofball on this.